Well, welcome to this edition of Peel, which I have to say is even more frantic than normal, because every time I look on the BIS website, the Department for Business Innovation and Skills, there is a new proposal about employment law, and we have a lot of new legislation. So we have quite a busy day, but I hope you'll find the notes reasonably comprehensive about the two pieces of legislation we have been talking about a lot this year, which is the Bribery Act and the agency work regulations. And we're going to sort of do our last run round on those, given that guidance for both has now emerged from the government in final form. So we're now in a position to say much more definitively precisely where the law is on these topics, and more to the point, your position as employing organisations and how it's going to impact on you. So I'm not going to look at some of the broader issues, I'm going to look at how it affects the HR role, as it were. Okay, our special topic by special request was gloom and doom, terminating contracts, and so we'll do a quick run through of that and look at one or two new pieces of case law, which is very much around selecting people for redundancy, which is getting more complicated. What we always start off with is an update about where we are on law making and policy making and general developments, and then we look at important case law. There is actually very little important case law today, but that's not always the situation. If you have a job application from a Bulgarian or Romanian now, they have the same rights as other nationals of other EU member states. So the Bulgarians and Romanians now have full EU membership. But we have got a few things to keep our eye on of a more tangible nature, and the first thing is that we are needing very soon to transpose the parental leave directive of last year, which increased parental leave from 3 to 4 months. Now, as we'll see later today, this obligation has been entirely overtaken by a consultation that was published on Monday called Modern Workplaces, which we'll come back to, which is proposing radical changes on maternity, paternity and parental leave. We shall certainly be hitting our target of 4 months, I think, when that comes to pass. These proposals are very radical, so we'll have to return to them at the next Peel session when they've had more chance to really assess their importance. And I'm going to a conference on Wednesday where they're going to be discussed in detail anyway. But so there's that we need to do, and also we need to keep our eye open. Don't forget, your freelance female staff, your consultants, your people who work for you through their own limited company or whatever it is on a self-employed basis, we are now preparing for them to have basic maternity rights, which means that they will have an entitlement to maternity leave and to basic statutory maternity pay. It's really, really important to keep your eye generally on the rights that are now beginning to be accrued by self-employed people. The other depressing thing is this maternity draft. Now, can I just remind you, this is the draft which became controversial. Most of it is not controversial because, for example, it includes the right of a woman returning to work to request flexible working, such as we already have in the UK, and to incorporate some European Court of Justice judgments on maternity protections. But the big issue was the demand by the European Parliament of 20 weeks on full pay as a basic minimum. I think just a reminder that a majority of EU states already have that. It seems to me that the Modern Workplaces consultation from last Monday that I just mentioned will make it even more difficult for us to comply with that kind of proposal. At the moment, the Commission, the European Commission, and the European Parliament are talking about it, but there isn't a great deal of optimism around that this will be adopted in the near future. The reason I have shown that map is because one of the topics we're looking at today is, as I said, the agency work regulations and the strategy of that legislation, and it builds on the Posting of Workers Directive of 1996. Can I just remind you what that does? It says if an agency, if an outsourcing company, if an employer sends somebody to work in another member state, they should not receive terms and conditions of employment less favourable than those enjoyed in the organisation or the state to which they have been sent. So, for example, anybody being sent from, say, Poland to the UK is entitled to our national minimum wage. Okay? Anyway, the other one I'm sure you've been having sleepless nights about is what on earth is happening to that working time amended draft. So where we are on this is there's an attempt being made between the employers, Business Europe, and CEEP, which is the public sector employers, the small SMEs, and the trade unions, to see if they can get any agreement. Just a reminder, the areas which are controversial is the question of the opt-out, the question of on-call standby time, how it should be viewed, and more importantly, how it should be paid, and the very controversial issue about time off in lieu, what's called compensatory rest, if people work excess hours. Can I just say that the area that is the most significant part of case law across Europe is this question of recognition of qualifications. I mean, you've probably heard of the Lisbon process, which is about trying to harmonise academic qualifications, degrees, postgraduate qualifications across the EU, but there's also the issue of vocational qualifications, which most of the case law has concerned. Let's move back into the UK. The Bribery Act comes into force on the 1st of July. On the whole, the Bribery Act is a consolidating act of other corruption legislation dating from the 19th century. But the new offence, which is to give it teeth, as you know, is that an organisation can be liable for a very hefty fine. It's a crime of the failure to prevent bribery. So the first thing you do is you have to make an assessment of the extent to which you think your organisation is prone to people either giving or receiving bribes that will change the decision-making process. You must have done by the 1st of July a risk assessment for your organisation on the extent to which you believe you are at risk of bribery. Right, number one, risk assessment. You need to write it down. Do all your same stuff as health and safety law. If you're doing a risk assessment for health and safety, you would record it in writing and identify, wouldn't you, people especially at risk or situations particularly at risk. It's exactly the same thought process for the Bribery Act. Okay, top level commitment. Now, in your organisation, who is mainly got the responsibility for implementing this legislation? Like health and safety, it could slip between various executive roles. So who's your champion? Who's your leader? And are they actually providing leadership? Why should the HR department not lead on this? You need a policy. You need to have it written down. You need to have an idea about what's in the policy, who's covered by it. We've mentioned the auditors. But we could also talk about, we must include our consultants, our agents, our non-employees. Anybody who represents the organisation is covered. So they must be part of the policy as well. So the training has to tell you what to expect. It has to explain what gifts you can receive and not receive. I know places now that don't allow any employees to receive any gifts from anybody. You have to explain what bribery is very clearly in training, how to handle it. It's not just saying, oh, I'm sorry, I don't accept bribes. I mean, the person who's actually offering you a meal or a theatre ticket or a ticket for the Olympic Games might well be a good customer. So it's not just a question of saying no. It is, you know, look, we have an ethics policy and we'd love to do business with you or not, or we'd like to talk to you, but I'm afraid this proposal you're making I'm unable to accept. It's contrary to our rules. I think we've got used in this country to treating part-timers much as full-timers. We don't see them as a different species. Fixed-term workers, I think, we're not quite so comfortable and easy with. But when it comes to agency temps, because of the triangular relationship and because you're not their employer, we see them as different. 4% of our workforce at least is temporary, at least. And we are the largest user of temps in Europe. The problem with these regulations is it treats everybody the same. Okay? So you have to think in terms of pay, but only pay. They must be treated as if they are one of your own. Remember what the regulations are trying to achieve. They're trying to protect some vulnerable people. The strategy they have adopted is anti-discrimination law, which is no less favourable treatment, at least in terms of day one rights to social facilities and antenatal care, but also in terms of pay and pay based on performance. To achieve these objectives, they have set in place a most horrendous bureaucratic structure where you are having to monitor, communicate, liaise very closely with the agency. It is such a farce, these regulations, because all this frothing and shouting and writing and angst, 55% of temps assignments are for less than 12 weeks. Anyway, another 10% or so will be ruled out either because they're self-employed in business on their own account, people we think are in other exempted areas, people like we would have thought were bank nurses and things like that, they're not covered. So these people who are vulnerable but are excluded, they're not covered. I reckon no more than 30% of temps actually will be covered.